What happens when a country's most decorated living soldier is formally charged with war crimes after years of legal battles? And what does that reveal about accountability in modern warfare? In Australia's case, the arrest of Ben Robert Smith in April 2026 marks a rare moment where allegations tied to elite Special Forces operations in Afghanistan have moved from civil findings into the criminal justice system. This development raises broader questions about how democracies investigate conduct during overseas conflicts without yet determining the final legal outcome. If this situation escalates, it could redefine how military accountability is pursued in Western countries, particularly for special operations forces. A successful prosecution would demonstrate that even highly decorated individuals can face criminal consequences based on evidence gathered years after combat. If the case fails due to evidentiary limitations, it may reinforce the difficulty of prosecuting alleged crimes committed in distant war zones. If proceedings remain prolonged and inconclusive, the result could be a continued gap between legal standards and public expectations of accountability. The roots of this case lie in Australia's military involvement in Afghanistan between 2001 and 2014, where Special Forces units, including the Special Air Service Regiment, conducted counterinsurgency operations. During this period, small teams operated in remote regions with limited oversight, often engaging in high-risk missions against Taliban forces. Over time, allegations began to emerge regarding the conduct of some personnel, particularly involving the treatment of detainees and non-combatants. These concerns culminated in the 2020 Brereton Report, a 4-year investigation led by Major General Paul Brereton. The report found credible evidence that 39 unlawful killings had been committed by Australian Special Forces personnel, and recommended that 19 individuals be investigated for potential prosecution. This marked a significant turning point, as it shifted the issue from internal military review into the realm of criminal investigation. In response, the Australian government established the Office of the Special Investigator to pursue these cases. At the center of the current charges is Ben Robert Smith, a former corporal who served multiple tours in Afghanistan and was awarded the Victoria Cross, Australia's highest military honor, for actions during a 2010 engagement against Taliban fighters. After leaving the military in 2013, he became a prominent public figure. However, in 2018, media reports began detailing allegations that he had been involved in unlawful killings of unarmed Afghan civilians. Robert Smith denied these allegations and initiated a defamation lawsuit against the publishers. The case ran for 7 years and became one of the most closely watched legal battles in Australia. In 2023, Federal Court Justice Anthony Basanko found, on the balance of probabilities, that Robert Smith had been involved in multiple unlawful killings, including incidents where unarmed individuals were allegedly executed and where subordinates were directed to carry out such acts. This was a civil judgment, meaning it applied a lower standard of proof than criminal law, but it established a detailed factual record. The transition from civil findings to criminal charges occurred in April 2026, when the Australian Federal Police arrested Robert Smith at Sydney Airport. According to Commissioner Chrissy Barrett, the charges include 1 count of murder, 1 count of jointly committing murder, and 3 counts related to aiding or directing unlawful killings. Authorities allege that the incidents occurred between 2009 and 2012 and involved unarmed detainees. Robert Smith continues to deny all allegations. The investigation faces significant structural challenges. As Ross Barnett from the Office of the Special Investigator explained, the alleged crimes took place approximately 9,000 kilometers from Australia, in environments where forensic evidence is limited or inaccessible. Investigators do not have access to original crime scenes, physical evidence such as projectiles, or even direct access to victims. This reliance on witness testimony and reconstructed timelines makes the legal process complex and uncertain. This case also reflects broader institutional dynamics. The Australian Defence Force has emphasized that the allegations concern a small subset of personnel, while maintaining that the majority of its members serve with integrity. Political leadership, including Prime Minister Anthony Albanese, has avoided direct commentary, citing the importance of judicial independence. Meanwhile, public institutions such as the Australian War Memorial have begun reassessing how individuals like Robert Smith are represented, reflecting the tension between honoring service and addressing allegations. One possible scenario is that the prosecution successfully meets the criminal standard of proof beyond a reasonable doubt. In this case, the trial could set a precedent for how war crimes are pursued domestically, reinforcing the principle that military service does not exempt individuals from legal accountability. It could also encourage further investigations into other cases identified in the Brereton Report. A second scenario is that the case does not result in a conviction, either due to insufficient evidence or the inherent difficulties of prosecuting historical wartime actions. This outcome would highlight the limitations of legal systems when dealing with conflicts characterized by incomplete records and contested narratives. It may also lead to renewed debate about alternative mechanisms for accountability, such as truth commissions or military tribunals. The geopolitical implications are more subtle, but still significant. For Australia, the case affects its international reputation as a country committed to the rule of law and human rights. Demonstrating a willingness to investigate and prosecute alleged misconduct can strengthen credibility among allies and partners. At the same time, it may also expose tensions within military alliances, where similar allegations have emerged in other countries but have not always resulted in comparable legal action. At a systemic level, the situation illustrates the evolving relationship between military operations and legal oversight. Modern conflicts often involve decentralized operations, rapid decision-making, and complex rules of engagement. When allegations arise years later, legal systems must reconstruct events with limited evidence, creating a gap between operational realities and judicial requirements. This tension is not unique to Australia, but reflects a broader challenge faced by many countries involved in long-term overseas deployments. What emerges is a case that sits at the intersection of law, military conduct, and public accountability. It is not only about the actions of one individual, but also about how institutions respond to allegations of misconduct within their ranks. The outcome will depend on the ability of prosecutors to present credible evidence, the defense to challenge those claims, and the courts to assess them within the framework of criminal law. As the proceedings move forward, the key variables to watch include the strength of witness testimony, the handling of classified or sensitive information, and the broader institutional response. The case will likely unfold over an extended period, reflecting its complexity and significance. The central question remains unresolved. Can a legal system deliver definitive judgments on actions that occurred in the fog of war, years after the fact and far from the courtroom? The answer will shape not only this case, but also future approaches to accountability, influencing how societies balance the demands of security, justice, and historical truth.